welcome to Legally Speaking with me, Tarun Nangia. This is the grand finale of our series on Justice Suryakant as Chief Justice of India, opportunities and suggestions. And I have an eminent panel who joins me today. I want to welcome Justice Arjun Kumar Sikri. As we all know, he has served as a judge of the Delhi High Court, the Chief Justice of the Delhi High Court, a judge, the Chief Justice of Punjab Haryana High Court, where Justice Suryakant also served in his formative years. He has then served as a judge of the Supreme Court of India. Currently, he's one of India's leading arbitrators and is a sitting judge of the Singapore International Commercial Court. Good to see you, and thank you for your time. I have with me Ryan Karanjawala. He's managing partner of India's leading litigating law firm at the Supreme Court of India, the Delhi High Court, and other forums. And it's a pleasure to have him on the show today. On the grand finale, no less. Thank you for your time. We have with us senior advocate Parag Tripathi, one of our very fine commercial minds and leading lawyers at the Delhi High Court and the Supreme Court. He also serves as the Additional Solicitor General of India. So I can successfully say he bats for both sides equally well. Good to see you and appreciate that you gave us time for this. At the outset, let me request Mr. Karanjawala to give an opening comment, and then we move on to detailed deliberations. Over to you, Mr. Karanjawala.
So, Tarun, I have said it before and on your show, and probably both my companions have already heard me say this, but it's something that in my mind bears repetition. The Chief Justice of India is not just the Chief Justice of India. He also occupies, according to me, the position of the most powerful judge in the whole world. And the reason why I say it is fourfold. First, look at his jurisdiction. He sits in jurisdiction over 1.2 billion people. No other democracy in the world and no other judge in the world has such a large physical jurisdiction. Secondly, look at the jurisdiction of the Supreme Court, which he presides over. The Supreme Court of India has an all-encompassing jurisdiction. You can almost call it super magnetic in the sense that any case filed anywhere in India can always meander itself right up to the Supreme Court, provided the litigants so desire. So it's an all-encompassing jurisdiction. Again, very different from the jurisdictions of different courts. So these two things alone would make him one of the most powerful judges in the world. In addition, he has two additional factors in his favor. One is that under Article 142, he has the right, a constitutional right, a constitutionally given right to do complete justice in the case, which sort of allows him to cut through the cobweb in a case in which he so desires. And the fourth point is that he is the master of the rolls. In the Supreme Court, it is he who decides which benches take up which kind of matters. And that itself can really, in a sense, shape the way the court moves in a particular direction during his tenure. Keeping that in mind, what, according to me, should Chief Justice Suryakant do? Well, I think the best thing he can do is to play to his strengths. What are his strengths? First, he was one of the youngest advocate generals appointed. So he has already got a sense of how governments work, which is very important when you are the head of the institution. Second, he was a judge in two separate high courts, apart from, of course, being also in the Supreme Court. So he has a deep idea of how the judiciary functions, the nooks and crannies of judicial work, administrative work in the judiciary. Third, his other strength is that unlike his predecessor, he has a 16-month tenure as Chief Justice, which is not huge, but it's not small either. It's enough to accomplish what you want to do. And the fourth strength that he has is he has a practical problem-solving mindset. which will enable him to handle the problems of the moment rather than get bogged down in the intricacies of what is happening in the court or what is happening with government. And the last is, in my opinion, he also has the affection of the bar and the strength and the support of the brethren. In such a combination, with all these things before himself, I think the first thing he should do is to deal with the huge number of delays in ensuring that the sanction strength of the High Court is up to its full maximum. In my opinion today, and I'm going to end here, since this is just an opening comment, and then I'll go later into what I feel he should do for this particular problem. According to me today, with the areas the way it is, the sanction strength, though it is actually a maximum number, is in practical terms really a minimum number. That's the least, actually, in my opinion, that should be the functioning strength of a high court. And Justice Suryakant, in these 16 months, according to me, should do his best to see that the glass is as full as it possibly can be. And I won't continue here. I'll just stop. I'll leave it to my colleagues to take on the matter further. You're mute.
Thank you for the opening comment. The humility of Justice Suryakant could be seen in the fact that once at a function, when Justice Sikri arrived and he was sitting in the first row, and Justice Suryakant was on the dais, he stopped and he said, "My Chief Justice has come." And this is long after Justice Sikri had demitted office. He's an arbitrator. But the graciousness with which he acknowledged his presence and stopped everything and said, "My Chief Justice has come." And then, of course, continued. That
But let me
shows.
say one thing. Let me add here one thing, Tarun. As far as Justice Sikri is concerned, he doesn't have to be a chief justice. All his junior judges hold him in the same affection and would have said the same thing because all of them hold him in that affection.
So I think it is something that shows both in good light, that both there's affection for each other, which is continued far beyond their terms in office. I mean, he's still in office, but that is something which shows. So your opening comment on Justice Suryakant.
Arjun, you're on mute. Up mute, Pro.
Yes. Thank you, Ms. Nangia and my two panelists. And I think this is our now favorite team as far as
That is
three
true.
programs. It's a combination
That-
of three of us, which you
That's true.
choose and pick up, and we are really delighted by that. And I first of all, as judges, when they write judgment and other person is writing judgment, they say, "I agree." So let me start with this. I entirely agree with what Mr. Ryan Karanjawala has said. And
Thank you.
just to add to that, and to your comment also of that anecdote which you have mentioned about Justice, or I would say Chief Justice of India now, when he did that and arrived in the program, and then in the middle of his speech, he referred to me. Actually, this is his humility. You are very right. And that's the reason, at least I may say so from my days in Punjab and Haryana High Court, the kind of affinity and the bonding we developed at that time, which continues. If I may tell you one thing here itself, which will be relevant in some other context as well. When I was Chief Justice there, what happened on some issue, some tiff between a security personnel who was a police officer and one lawyer, senior lawyer. So the bar went on strike. And of course, we had done a lot to diffuse the situation. He was at number 10 or 11 in seniority at that time. We have the collegium of three, chief plus the two, and we have the administrative committee also in the high courts, which are first seven judges. So he was neither in the collegium nor in that administrative committee. But as I knew and I was told, and that was the occasion where he proved himself that he is one person who will be able to resolve this tension between the police and the bar or the advocates, etc. So I called him. I requested that you have to intervene. And I think within 2 hours, he called me back and he said that from tomorrow, lawyers are going to work and it is all resolved. So that is, of course, that may be called as his, when we come to mediation, etc. So he himself is very well equipped. And
That's right.
so therefore, that was, I had that kind of trust in him. Even he was, as I said, number 10 and 11, he was not in the collegium. But for many matters or many things, I would consult him and will take his inputs because I knew he is the person who is going to give his views dispassionately and objectively. What is right, he is going to tell me that. Because when you are a Chief Justice and you are going from another High Court, you have not worked in that particular High Court and you are oblivious of so many things. And it is your colleagues there in that court which will be able to uh, uh,
Guide you.
to tell you or rather even guide you also. So he assumed that role significantly during my tenure as Chief Justice, and that is one reason that we had that bonding and which continues that mutual respect for him. I would say his respect for me and my love for him. And as Ryan has rightly mentioned, a person who becomes Advocate General at the age of 37, you can understand that. But see his career graph, I see it from another, I mean, additional angle as well. A grassroots lawyer who started his practice from the district court. So he has complete, I mean, knowledge of how there is a working in the district courts. There are many lawyers who start only in the High Court or in the Supreme Court, and therefore they may not be knowing what is happening. But he has complete knowledge and how these courts work, what are the problems they face, and how these are to be resolved. So that he has. Then he comes to and he practices in the High Court, and at the age of 37, he becomes the Advocate General. But good thing is that he actually has a, as Ryan has said, robust common sense, and as I have seen him, he is very quick to grasp the thing. That's why he could understand the functioning of the district court. He could understand the functioning of the High Court. And after coming to the Supreme Court and in his initial years before becoming Chief Justice, he has fully understood how Supreme Court functions administratively, judicially, etc. So therefore, because why I'm emphasizing on this is that as Chief Justice of India, of the most powerful court, as Ryan has mentioned, he is not to only look into the functioning of the Supreme Court. He has to ensure that the high courts and subordinate courts in India also function properly, and wherever assistance is needed, wherever guidance is needed, because he is the head of the state. And in that sense, head of the judiciary, not state, the head of the judiciary. And in that sense, naturally, he is in a way guide and mentor, maybe become mentor to many, many persons. So therefore, the kind of vision which is required, he has the wherewithal. And he has complete expertise in that, if I may, as I have seen. Because in last 2 3 years, I've seen the way he has been able to tackle these many of the issues, even in the Supreme Court at Supreme Court level. It seems that yes, he has been able to grasp the problems also, the metrics also, how these courts function very quickly. And another quality, if I may say so at the beginning, is that he walks the talk. He is not a person who would say something but will not implement on that. So once he says, he knows that it is to be done. And if he makes a statement as Chief Justice of India, obviously, to which we'll allude to, obviously, then that means that he is knows that he's making the statement as a most responsible person of the judiciary, and therefore he has to then ensure that what I have said is implemented also. So he is going to make his best efforts in whatever manner he is going to, I mean, discharge his function. And there is what I say, he's made so many statements how he's going to function, which will come to that because as these are the initial remarks. but then his commitment and honesty of purpose, that what he wants ultimately as Chief Justice of India, and that at the back of his mind is the interest of the institution. At the back of his mind is that the institution, the judicial institution, should regain some of the regain the earlier glory, some of which is lost in recent years. So he wants to achieve that. And therefore, in the beginning, in my introductory remarks, I'll say my good wishes to him, and I think he'll do well. That is what we expect of him.
Thank you for that beautiful opening comment. He said much fonder things in person about you, but that should be off camera. So I would only divert so much now. I'll go to Senior Advocate Parag Tripathi, about whom a solicitor told me that he charms his way into the judge's mind to get an illicit an order. And sometimes if that takes a couplet of two, even that is delivered. That we shall see if he's delivered in the course of this program too. But I would request him to give the opening comment.
Yes, thank you so much, Tarun. And of course, I agree with what both Ryan and Justice Sikri have said. There's a great amount of interpersonal skill, of empathy and sensitivity, which are, of course, very important. However, though, of course, being the Chief Justice is the zenith of the achievement in our profession, it's not a bed of roses. There is so much work to be done and often so little appreciation. So one needs that kind of commitment, which we are all agreed is there. Broadly, I think the areas which require consideration are, of course, of judicial work, which will also include his position as the master of the roster and assigning of benches, and structuring the court functioning, when to have final hearing, how many final hearing days in the Supreme Court, and also in the High Courts and the district courts. So there, obviously, the Chief Justice is not the master of the roster, but he can structure the system in a way so that with the given resources, you get the maximum output. Then there is the administrative side of the role of the Chief Justice, which also includes his being the paterfamilias of the entire judicial fraternity and the legal fraternity, and which has its own demands. There's also a requirement to a push to continuity, because many times we find that good ideas of previous Chief Justices are not continued, or ideas are not carried forward like they should as an institution. As we all know, in the American Supreme Court, you can have a Chief Justice for 20 years. So there's a continuity. The courts are known by the names of the Chief Justice, and they have their own political philosophy in that particular period of the court. So we need to look at that as well. And I think the two most critical areas, and as Justice Sikri said, we'll deal with it later when we come to it, the two most critical areas are the shortage of judges, both in the High Court and the district courts, and the shortage of supporting staff, particularly in district court, where the conditions require to be greatly improved, because our district court has actually some of the finest legal minds, and of late I'm told the kind of youngsters who are applying for being inducted in the district judiciary is absolutely top class. Therefore, this entire global view has to be taken with a degree of empathy and sensitivity, so that the whole structure functions in unison. It's a role of both a captain and a coach and an inspirational leader, which is very much easier said, a very difficult role to play, but I'm sure he will be in a position to deal with it in the manner it deserves. And of course, the fact that there is about 14 months of his tenure makes it greatly a tenure where these goals can be achieved and visible goals can be seen to have been reached.
Thank you, Senior Advocate Parag Tripathi. But when you said of capability, I think you amongst all of us went to Harvard in 77, if I'm not wrong.
But yeah, that's all right. Makes no difference.
So, and of course, we have one gold medalist amongst us, Justice Sikri in college. I repeat this because a lot of new viewers may not know these facts and they should be told.
Parag was also gold medalist.
Oh, no, that also.
Yeah.
Glad to know that. So,
Except that
and so,
Justice Sikri had in all, I think, six, because it's a 3-year course, because he topped every semester. So he got a gold medal in every semester. So he has
Wow.
6 gold medals. He has the all-time record because there aren't more than 6 semesters and nobody else topped when he was there.
I didn't know that much, but thanks for sharing this. Mr. Karanjawala, if you want, we move to the suggestions, 2 or 3 suggestions that you would like to give Justice Suryakant. And you've seen so many Chief Justices in your career because you predominantly since 83, 84 had a Supreme Court
79.
practice.
From 79.
79.
When I was in Parik and Company. Yeah. I was
Yeah.
born
So you talk.
in Chandrachud's court, the senior Mr. Chandrachud.
Oh. So
So what I
it's been
would
a
say
real.
is that today, just look at what is the sanction strength of the High Court. There are 25 High Courts. If you look at the permanent and additional judges together, then the sanction strength is, to be exact, 1122. That is 1,122. At the moment, give or take a little bit, because these numbers may be a little outdated, there is a working strength of 825, which means there is a vacancy of about 297, which means about 300, which means that actually the high courts in the teeth of mounting areas are functioning at 75% capacity on if you take an overall uniform basis. I think that is the greatest problem that faces the Supreme Court today and the Chief Justice in particular. And as we have all gone over his background, his ability to solve problems, his ability to carry both the bench and the bar with him, I think what he should do is utilize his collegium to its full extent. So there is a normal collegium. He should also mentally, in his mind, make a future collegium that is of all a collegium separately in his mind of all the people who are going to be chief justices, so that there is a certain sense of continuity in what he wants. And then he should allocate to each of these judges 2 or 3 high courts, which they can repeatedly visit, along with maybe somebody from that high court, if there is somebody from that high court in the Supreme Court, and gently prod the Chief Justice, talk to the members of the bar, and gently prod the Chief Justice of that court and the collegium of that court to ensuring that the vacancies are filled as fast as possible. So, at least from the side of the judges, once you allocate the work amongst yourselves and you work as a collective and cohesive team, then things get done much quicker, because leaving everything to one person in a limited tenure of 16 months is a little unfair. So, what one should do is he could easily take his brethren into confidence, allocate work amongst them, and they repeatedly go to the high courts and keep prodding and talking and prodding and talking till the sanction strength, at least as far as the judges are concerned, is suggested to the government. Then, of course, collectively, once the judges get together, and when the government sees that this is not an effort of just the Chief Justice and his collegium, this is an effort of his collegium and the future collegium of Chief Justices, who all sort of separately also function. Things are bound to improve, and you are bound to get far more judges than you would have got in the normal course of time. So let us say that if he leaves his tenure of 16 months, and instead of having a vacancy of 300 in all, he manages to leave behind a vacancy of only 150 or 100 judges, then I think he would have achieved a lot. Because in the teeth of mounting areas, the real thing that you have to do is to ensure that the court is manned to its full strength as far as possible. That's my one suggestion. I have another, But I'll keep that for a later occasion if it comes.
Point well taken. I'll go to Justice Sikri for his suggestions for Chief Justice of India, Justice Suryakant.
Yeah, I think Ryan has rightly mentioned about the filling up of the vacancies in the High Court. I see it from broader perspective. This what Ryan has mentioned, that is the pendency and backlog, which is really a big problem today. If you see, uh,
Give me a minute. There's
yeah,
a power
if
cut.
you see at the time of COVID, that is around 2020, we had the pendency of about 30 million cases. But this 30 million
Oh,
cases
yeah.
was there for many years with the reason, and what was, of course, we used to say 30 million, but it is not that those 30 million cases are pending and they remain. New
On
cases
the
are coming,
generator.
old cases are, but the filing of new cases is so much that even if they are disposed of, large numbers, still pendency remain 30 million. But to that, if I may add, this 10 million cases at that time, if you remember, the figure used to be filed every year. That means courts were disposing of 10 million cases. That's why the pendency remained at 30 millions. It was, at least if it was not coming down, it was not increasing, and the courts were performing really well. Now, pendency has gone to, it has crossed 50 millions. Post COVID, because of COVID, yes, courts could not function. Not in spite of, functioning of court in mode and in a hype, earlier online, then hybrid, etc. also. But then naturally, with this, you won't be able to function with that this efficiency, which is when the courts are in-person hearings are there, physical hearings are there. And I remember post-COVID, we said after 2 years, in 22 or early 23, that the pendency has gone to more than 40 millions. But even thereafter, it is increasing. It has gone to 50 millions. So therefore, we have to see the reason. One reason is, Ryan has rightly mentioned, the paucity of judges. Not only we need more judges than the sanction strength in the high courts
Correct.
and subordinate courts, but even the sanction strength, we are not able to fill up that, which Ryan alluded to. So therefore, I think there has to be a 360-degree view of the matter as to how we reduce dependency. Appointment of number of judges is one. He has, good thing is that it is in his mind. Justice Suryakant has already said that this is his, if you remember, immediately after assuming the office, when he gave the public statement, he said that in first and foremost in my mind is to deal with dependency and backlog, and it has to be reduced. Now, coupled with that, another thing with which he has come again, and that is in his mind, and it is not that we are suggesting, it is that national shift towards mediation for nation, that slogan, which a beautiful slogan which he has really conceived, and he has conceptualized, is that mediation has to be for the entire nation, that is entire judiciary has to be roped into that, because we know the benefits of mediation. If we see what is happened in other countries, in many Western countries, in US even today, and US also was suffering with same problems in 1970s, early 80s. I remember I have still in my library the books about US judiciary at that time, and written about their arrears and how much arrears they are facing and the backlog they are facing. But that position is not there today, and it has happened because of the miracles of mediation. Even today, 94-95% cases are settled through mediation. So if out of 100 cases, now we have if 50 million, and if 94-95% cases can be settled, if we can't reach that figure, in few months, and it will take time, and not even within his tenure of 16 months. But if mediation is a movement which gets started in its true sense, it is there for last 20 years. It has picked up momentum, no doubt about it. Initially, there was a problem that whether it would be accepted at all by the bar or not. There is a general acceptability now. We are working on this, how it can be. So, therefore, yes, to whatever mechanism he does it now, which he has in his mind, mediation for nation is would be one thing. So, we are again coming back to the backlog and reduction. What I feel is another thing which is that is litigation. He'll have to work with the government on that litigation policy. We know 50 to 60% cases are of the government, and the government or government undertakings or semi-government bodies, etc. So every case they have to necessarily take up to the Supreme Court and file appeals after appeals, which may not be necessary. And if we look into the economics, whether the government is ultimately spending more money and what they are realizing. But government itself is conscious of this, but they are not able to, I don't know, find a solution to this. They have been coming out with the litigation policies in what cases appeal will be filed, not filed. And of course, as we know, nobody wants to take risk here because tomorrow CVC against a government officer who writes on the file that it's not a fit case for appeal. So after 5 years, there is an inquiry against him. It was a case fit for appeal. Why you have not filed and all. So nobody want to take chance. But then there are measures to tackle those situations also, which are very much within the knowledge of the government. But concrete steps are to be taken. And here, if he can, I don't think it would be in any case, giving away your independence. But on this arrears and litigation policy, if you can impress upon the government and ask them to work on that and really implement that. Parag said rightly so that nowadays some of the judicial officers who are coming are excellent. But at the same time, I would say in order to now the existing judges, their disposal rate, if it is to go up, it's not only that they have to decide and dispose of the cases. The judgment should also be qualitative judgments. And here he should strengthen again. It is already there in place, judicial academies, state judicial academies, as well as National Judicial Academy for the training of judges. And because every day new subjects are coming because of this technology, the judges are, we never studied anything about the cyber crimes in our law days because there was no such thing. We never studied about the technology laws. We never even, of course, there was something about the airspace law, etc., but not to the extent it has come now. There are many intellectual property cases. They were only within the geographical boundaries only. Now they are cross-border. Somebody may, sitting in some other country may take away your intellectual property rights and where jurisdiction lies and all that. These were not the issues in our times. And these issues are not, these are getting, as the technology is, scaling up, these issues are also getting more and more complex. So therefore, training to the judges is required. Likewise, training to the lawyers is required. I would say here, and again, for backlog only, not only judges should be trained. And if I don't know if you had read that article which was written by Professor Rajkumar immediately after he had to take over, and he has said he has given few suggestions, and one is National Academy for Lawyers should also be there. So I think it's a very, very good suggestion. And other things which he has himself stated, and I may, although I have in a way covered that, and he is conscious of that, but then it has to be, taken in a very serious manner, is that technology assisted judicial process. We had the time when earlier chief justices and in earlier times that technology is in place. Now, how it is to be utilized, to what extent AI can be utilized, he has already stated about these also in last few days. So he's including this, how the cautious adoption of AI, as he mentions, is to be done. He has said about, which is again very, very important, is that about the access to justice and legal aid expansion, which should be given because access, we have all, at the end of the day, social justice is to be done by our courts, particularly Supreme Court and High Court. And therefore, access to justice and legal aid become very important. He was when Justice Gawai was Chief Justice, naturally he was the head of NALSA. So he has worked in that and he has performed tremendously well. So he has full knowledge of how it has to be expanded, and he has talked about that. And another important thing which he has said, and this is really interesting, is that this, as I said, much development is taking place, and development is taking place in laws also everywhere. But what we have to adopt is what he has called Swadeshi jurisprudence. So we have to now, this is a term which he has coined, and I really admire him for that, that it has to be rooted in our Indian constitutional culture. And so these things are in his mind, and let us hope that he is able to work on that. Uh, no,
Thank you for all the suggestions and insight you just shared with us. We will now go to Senior Advocate Parag Tripathi for his suggestions. Over to you.
Thank you, Taran. I of course agree with the ideas of both Ryan and Justice Sikri. I call the collegium idea of Ryan as an immediate and continuing collegium. Immediate, which is the collegium, which is as understood today. Continuing, which will carry the torch of continuity, so that there is a consistency without break of various decisions which have been taken, hopefully unanimously. Also, the suggestion that there should be judges in the Supreme Court who should be requested to persuade the High Court Collegium to come up with names in order to fill up the delays in appointment. And mediation, where the country expects just the Chief Justice to ensure and try his best so that it becomes an effective alternative to the formal adjudicatory mechanism. And I think one thing that will help there is to have genuine costs being awarded in litigation, because that then acts
Yes.
as a very clear deterrent. Because today you fight a matter and the cost will be 1 crore, 2 crores in big matters, much, much more. And then you just walk away, no order as to cost. That has to stop. That is something which we don't afford as a nation. And lastly, I think Justice Sikri was very right how to deal with government as a litigator, which would require that interaction, which, as many retired judges have said, and rightly, that there is nothing wrong in the interaction. Because after all, these are various pillars of our society and governance. Now, I have a couple of suggestions, and then I'll try and give the promised Urdu couplet, without which Tarun will never forgive me. One, I think, both at the level of institutional approach and also at the level of infrastructural approach. Now, to come to the infrastructural part, it's already been covered, but I think there has to be a much greater push for VC, because I find resistance to VC at different levels. And not all resistance is incorrect, because many times it doesn't work, the voice comes loudly, but those are all things that can be settled if we get the right kind of technology and people who are looking into it. And we should have a direct connect between GRAP 1, 2, 3, 4 and compulsory VC. So if your GRAP becomes 3 and 4, you should automatically shift to VC, unless the court feels that this matter is so important that it still requires physical presence, because that will make things much easier across the board. I think institutionally, there is 2 or 3 suggestions, and of course, those suggestions would require far-reaching changes. But I suggest that there's a whole concept of preclusion. And that concept is a very interesting concept, which says that a party has a right to one full adjudication. That is the trial court adjudication, whatever the trial court be. And thereafter, appellate recourse should be limited only on broader public or systemic issues. I know this sounds very harsh, and we all know many, many times the trial court goes very wrong, but that too is human. If it goes wrong, it goes wrong. Because we have to deal with, as Justice Sikri said, this 50 million cases, otherwise won't go away. We have to, and our whole system will have a breakdown. Also with it, and that's my view which I have held for a very long time, for a greater harmony, particularly in the higher echelons of judiciary, I think there should be a uniform retirement age of High Court and Supreme Court judges. And just the present Chief Justice is one who can, while interacting with the government, sell this principle that that is something which will greatly benefit the whole system. Because if we are able to cut down our appellate recourse and review to the rarest cases, including the SLPs, of course, it will hit all of us lawyers who are litigational lawyers. And if we are able to have a uniform retirement age, which is something which a dynamic Chief Justice can give as an institutional input to the government, I think it will greatly help in sorting out many, many problems. And this whole difficulty which we see of judges who at the level of Chief Justices or J1 and J2 in the High Court are in some sense in the most vulnerable period of their judicial careers, that system has to change, because at that time they are the most valuable assets because they've had that huge experience. So I think that will be a way to harness that experience in a manner without creating personal difficulties for the people who have that kind of experience and are willing to serve. And of course, I'm very hopeful that the present Chief Justice will ensure that most of these things are met. There's a very interesting poet called Musafi in Lucknow who said this, of course, about himself, but this applies as an address from a lawyer to our entire litigation system. Musafi, हमने सोचा था कि होगा कोई दाग. So I thought that there will be some दाग or जख्म and we'll deal with it. तेरे दिल में तो बड़ा काम रफू का निकला. So there's a huge work which requires and Rafu is very important. Rafu is not stitching. It is in a manner which is done very delicately. So I think our Chief Justice is the right person for giving this Rafu to this huge pending heartbreaks and institutional breaks which exist in our system. Thank you.
Thank you. Thank you for such beautiful exposition of the suggestions that you did. Now we move to a round of good wishes to him for his tenure. Mr. Karanjawala.
So I think we speak for everybody and most of the members of the bar also when wishing him a long, successful, fruitful, and a happy tenure. And may the interaction between the bar and the bench become closer. May the judges' numbers increase. May the areas be reduced.
Point very well taken. Justice Sikri, any good wishes for Justice Suryakant for this tenure?
My good wishes will always be there for my younger brother, if I may put it like that. And what Ryan has said, I say I agree. And we hope and we wish that he is successful in his mission, which he has envisioned. And his career path up to now shows that he has been successful in most of his endeavors, and we wish him full success as Chief Justice of India also. And
Thank you.
I had told him when he became Chief Justice, shine, shine, and shine more, and keep
Yes.
shining. So I say that.
Thank you. Senior Advocate Parag Tripathi, your good wishes for Justice Suryakant.
Absolutely. I join whatever has been said. This is the third time I'm saying this. Whatever has been said by both Ryan and Justice Sikri. And I'm very sure that he will be able to take the whole Supreme Court at the level of the judges with him. Because that's extremely important. And Ryan had dealt with it very briefly. It's very important to have that cohesion and continuity and that unity of thought and purpose, because it changes the whole dynamics of the system. Thank you.
Thank you. And on this note, I would like to thank Justice Arjun Kumar Sikri, Mr. Ryan Karanjawala, Managing Partner of Karanjawala and Company, Senior Advocate Parag Tripathi, former ASG. Thank you for your time for this very, very special show for a much loved and liked Chief Justice of India, who definitely will leave a mark in the time of history with his tenure. Appreciate your joining us. Thank you so very much. Thank you.
Thank you.
Thank you, Tarun.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.